This is a high-stakes pretrial hearing for Jose Ruiz, a man accused in the horrific death of a 5-year-old girl. The tension is already thick enough to cut with a knife. Ruiz's girlfriend, the child's mother, has already taken a plea deal and is set to testify against him, painting him as the monster responsible. With his life on the line, his defense team comes out with a surprising and aggressive opening move, not against the evidence but against the court itself. Their target, the camera recording the proceedings and the judge allowing it. They argue the live stream is poisoning the jury pool and destroying his presumption of innocence before the trial even begins. The judge, however, is not one to be pushed around. This isn't just a procedural motion, it's the opening shot in a psychological war, a battle of wills between a defense team desperate to control the narrative and a judge who will not cede control of her courtroom.
A man accused in the death of a 5-year-old girl last year is now headed to trial. 5-year-old Mercedes Lozoya's mother was charged in the girl's death and took a plea deal in exchange for testimony against her boyfriend, Jose Ruiz. Jury selection for Ruiz's case will start December 12th. He could spend the rest.
Denied. The judge wastes no time shutting down the defense's first two requests. First, the request to recuse herself over the YouTube broadcast was already denied. Now, the request to hide the defendant in the jury box to shield him from the camera is also shot down. The judge's tone is firm and unyielding. She gives him two options: sit at the counsel table or stand. This is a clear power play. The judge is establishing from the outset that she is in command and will not entertain arguments she deems frivolous. The defense is trying to paint a picture of an unfair process tainted by media, but the judge is countering by sticking rigidly to standard procedure. The defendant will be treated like any other, front and center. This initial skirmish sets a confrontational tone for the entire hearing.
Rest of his life behind bars if found guilty.
Your Honor, has never been heard. Your Honor, I asked you to recuse yourself only for the purpose of the YouTube. That was the only reason I did it, and it was refused. But
all right, and that was denied by by another judge, correct?
Yes, because I couldn't prove it under civil procedure. However, I'm requesting and objecting right now because my client has a presumption of innocence, which has been discouraged by showing him in prison clothes in front of a live audience of over maybe 1 million people. I don't know. But his presumption of innocence has been damaged because of this YouTube experience.
All right, that's denied.
Could my client sit in the jury box so he wouldn't be in front of the YouTube?
I mean, we're here on a motion, so he's here, or either he can sit at the table. He can either sit at the counsel table or he can stand here.
He can sit at the counsel table.
All right, so y'all go back and sit at counsel table. All right, and what's the next motion?
Motion for judge to preclude use of YouTube and live streaming for video recording from any news source during the course of the trial in this case.
Any news source?
It's my understanding, Your Honor, some news agency in town is going to live stream this or intends to.
All right, I have no control over what a news person will or will not do. And I've already made a ruling over, I think I previously ruled on that. I have no control over what other people do.
You can't control your courtroom, Your Honor? You can't preclude them from being in here?
No, I'm not going to preclude the media from being in the courtroom. Why would I?
During the course of the trial.
No, why would I preclude them from being in the courtroom?
Because it's my client's right. Specifically, this argument mostly argues Texas Rule of Evidence 614, the rule. And it's not a discretionary rule, it's mandatory that once the rule is invoked, the judge shall require the witnesses. How do we protect?
Oh, are you anticipating that people from the media are going to come in to testify?
Not testify, record or broadcast. And the point is, under 614, we're supposed to be allowed to have witnesses testimony separate and no commentary and no viewing of it. Every witness is able to look on YouTube to see what's going on in the court.
All right.
Which means every bit of testimony will already be heard. TRE 614 is not just for language. It's about the rights of the client. And how do we protect his rights when every witness potentially has the ability to see every previous witness?
Well, the question is,
the defense's argument against live streaming is more than just about optics. It's a legal strategy rooted in something called the rule, or Texas Rule of Evidence 614. This rule is designed to prevent witnesses from hearing each other's testimony, ensuring their own account isn't influenced. The defense argues that a public YouTube stream completely demolishes this protection, as any witness can simply log on and watch the entire trial. The judge's counterargument is pragmatic. She can instruct witnesses not to watch, but she can't guarantee they'll obey with or without a camera. She essentially tells the defense that policing their own witnesses is their problem, not the court's. The motion to ban the media is denied. A major blow to the defense's strategy. They've lost the battle for the cameras.
Is whether or not they actually will do that. And the other question is whether or not people who are not precluded from the rule will tell them what they've seen and heard. So that's something you all will have to tell your witnesses. They're not allowed to view anything, which is the instruction that is given to every witness who testifies. After their testimony, the instructions they're given is they are not to view anything. If there was something from some news media source, they are not allowed to watch it. They're not allowed to discuss their testimony with anyone. Now, whether or not they end up discussing their testimony with anyone, does anyone really know? Unless they ask that question, be up to the request of the defense counsel.
Effectively, then, Your Honor, you acknowledge that there's no guarantee that your order will be followed by either side, defense or
Well, this is what I'm acknowledging. Can you make a guarantee that if there is no media up, whenever a witness completes their testimony and I instruct that witness that they are not allowed to discuss their testimony with anyone, can anyone here guarantee that that witness is not going to discuss their testimony with anyone?
Absolutely not.
So-
However, your testimony will be available to anybody to see.
Mhm.
And that's, I believe, a denial of my client's constitutional rights and statutory rights, specifically under Texas law with the Texas Rules of Evidence.
All right, your motion to preclude media, your motion to preclude YouTube is denied.
Thank you, Your Honor.
You're welcome.
Now, Your Honor, I have a medical appointment. I advised the court beforehand about the medical center. So it's Mrs. Braun's motion on the suppression. So I'm asking people to excuse now. My client doesn't object.
All right, Mr. Ruiz, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give would be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, state your name for the record.
Jose Angel Ruiz.
All right, you understand that technically Ms. Conley is your first chair attorney on this case?
ma'am.
And she is asking to leave to go to a doctor's appointment. Do you understand that?
Yes, ma'am.
Do you?
Just as the legal arguments intensify, a bizarre piece of procedural drama unfolds. One of Ruiz's lead attorneys needs to leave for a doctor's appointment. This is highly unusual in a major felony case. Notice what the judge does here. She puts Jose Ruiz himself on the stand, under oath. This isn't just a formality. She is creating a bulletproof record that Ruiz personally consented to his attorney leaving by making him state he waives his right to appeal on this issue. She is proactively neutralizing a potential future claim of ineffective assistance of counsel. The judge's frustration, however, is palpable. She then takes a moment to scold the defense team for their poor time management, explaining exactly why they had to wait all morning. She's making it clear she runs an orderly court, and they are not following the rules.
Have any objections to her leaving?
No, ma'am.
Are you waiving your right to appeal as it relates to her leaving the courtroom during these motions?
Not sure what that means.
All right, you want to discuss that with your attorneys?
For the record, Your Honor, I was here for the morning docket. It was changed to 2:30.
All right, for the record, everyone knows the rules of the courts are this. If you are ready to proceed, you approach the clerk, have them place their file up here. No one ever said they were ready to proceed on motions, so that's why we're here in the afternoon.
At one point, Your Honor, the court told Warren Wolf not to go near the coordinator while you were giving, while you were taking.
While we were on the record,
Yes.
yes. And so this is what ends up happening. And this is what the court saw. This hearing was scheduled at 9 a.m. Everyone in this court knows the rules. You've been in this courtroom before with the rules, and the rules are when you are ready to proceed, approach the clerk. They will pull your file. Your file will be placed here. I kept announcing throughout the court hearing today, hey, we are recessing exactly at 12. I said, nobody rush the court at 11:45 because we're recessing at 12. Nobody moved. People still were chatting and laughing in the box. Then I said, again, I made another announcement midday. Everyone, you all need to move with the purpose because we're recessing at 12. And then at 11:52, that's when I got an announcement that, hey, you all are ready on Ruiz. That's the first time anyone said y'all were ready. Nobody ever asked the clerk to pull a file. I cannot read minds and think that people are ready when they're not. So we're back to my question, Mr. Ruiz. Are you waiving your right to appeal as it relates to your counsel leaving the court today to go to her doctor's appointment?
Yes, ma'am.
All right. Thank you.
Thank you. May I have excuse?
Yes. All right. What is the next motion?
Oh. Can you hear me, Judge?
Yes.
Okay. So the next motion.
And if you and Ms. Efron, if you all need to readjust, you're more than welcome to do so.
Thank you.
Okay. So the motion I'm arguing today is labeled the title, second motion to suppress evidence, cell phone.
All right, just give me one moment. Let me find the motion and then I will hear you.
Okay. It was filed on December 11th, 2020.
Okay. All right. And counsel, this motion is not file stamped, so if you could just review it and make sure we're talking about the same motion.
Okay. Or I can make a copy of the file.
Oh, that would be great.
Okay. Let me go do that real quick.
Sure.
Okay.
Is this going?
Now we get to the heart of the matter, a critical motion to suppress evidence from a cell phone. This is a make or break moment. A motion to suppress is a request to exclude evidence from trial, usually because it was obtained illegally. We learned that a previous search warrant for this same phone was already deemed invalid and suppressed by another judge. That's a huge win for the defense. However, the state didn't give up. They went back and got a second search warrant for the exact same device. The defense is now arguing that this second warrant is also fatally flawed. The contents of this phone could contain the most damning evidence against Ruiz, so if the defense can get this second warrant thrown out, it could cripple the prosecution's case before the jury ever hears it.
Going to be evidentiary or just argument?
Just argument, Judge.
Okay. All right, then.
We have a couple exhibits, Your Honor.
No, I have a couple of exhibits.
All right. Then you can offer your exhibits.
Okay, thank you, Judge. So what I have here is the original search warrant from February 14th, 2022. Now, this was the subject of a motion to suppress on November 29th.
Okay.
And that motion to suppress was granted. So this is the February 22 affidavit and search warrant that has been suppressed.
All right. And what's your exhibit number?
I guess we'll make that defense one.
If you would do that.
Okay.
Yes, because it's destroyed some of it.
Okay.
All right. Thank you.
May I proceed, Judge?
Yes.
I'm going to try to use the microphone the best I can. Okay, so what I have here marked are defense exhibits A and B. So actually, the A is the February 14th, 2022 affidavit and search warrant that was argued on November 29th and suppressed. So I would ask the court to take judicial notice of that ruling from November 29th.
Okay.
And then I also have here defense exhibit B, which is a second subsequent search warrant from November 27th, 2023. So if I may approach with these.
Oh, yes. All right. Any objection to the admission of defense exhibits A and B for purposes of this hearing, state?
For purposes of the no.
All right, then defense exhibits A and B are admitted for purposes of this hearing.
Okay. And then, again, Your Honor, I'd ask you to take judicial notice of the November 29th ruling, and then the two, Mr. Ruiz's indictment, the indictment of the co-defendant.
Well, just one second.
Okay.
So the defense exhibit A You're saying that that was ruled upon, and I believe that was ruled upon by Judge Angelini,
Yes.
and it was motion to suppress was
2023.
all right. And then B, Defense Exhibit B.
A second subsequent warrant for the same device that was applied for and granted obtained on November 27th, 2020.
Your Honor, if you would allow us a few minutes to contact, I certainly am aware of the four corners of the document. However, I do need to confer as to whether that.
All right, so this is what we'll do. What we're going to do is we're going to finish this hearing. Everybody can enter in what they want to enter into evidence, unless, there are objections to it. And then the court can hear argument with regards to that document another day if people so choose to do that. All right. Any other evidence to be admitted, defense?
Not evidence.
Okay.
Just argument.
State.
Okay, Your Honor, I would offer State's Exhibits A and B. Previously made aware to defense counsel, but State's Exhibit A is a copy of the Detective Sizes prosecution guide.
Mm-hmm.
And State's Exhibit B is a copy of a screenshot message that was sent to our office.
All right. Any objections for purposes of this hearing?
For purposes of this hearing, yes, I don't think it's relevant.
All right. I don't know I know that A is a copy of the prosecution guide. I don't see, and what I will tell you all, usually in affidavits for search warrants where there's a suppression issue, usually witnesses are called. So.
Well, I think the defects in this warrant are well identified and contained within the four corners of the document, and I'm arguing the insufficiency of the affidavit.
And just like that, the high-stakes hearing for Jose Ruiz is put on pause. The judge pivots to another defendant, Mark Costa, who has been waiting and is trying to figure out where his own attorney is. This is a perfect glimpse into the chaotic reality of a busy courtroom. A judge's docket is a relentless treadmill of cases, and they have to switch gears from a murder pretrial to a routine check-in in a matter of seconds. It's a logistical juggling act that requires immense focus. For Ruiz and his team, this is a moment to catch their breath and regroup as they wait for the judge to finish this brief but necessary interruption. But their legal chess match is far from over, and we're about to get right back to it.
It forms the basis of the warrant within the four corners of the document. And the court's already identified one of the issues, and I have others.
And Your Honor, if I could respond to that.
Yes.
She did introduce the old search warrant, which for purposes of the hearing, I let it in just because I know the court was not present on that day. However, if she's trying to.
This is a brilliant, if risky, move by the defense attorney. She introduced the old suppressed warrant as Exhibit A to show what was wrong with it, and the new warrant as Exhibit B. The prosecutor saw this as an opening and tried to introduce her own exhibits to prove the new warrant was based on a totally new, independent source of information. But the defense attorney immediately objects, arguing relevance and hearsay. She cleverly states her argument is based only on the four corners of the new warrant, meaning the judge should only consider the text written within that document itself to decide if it's sufficient. She's not arguing about new information. She's arguing the information in the warrant is poor quality. This forces the judge's hand.
Make some link between the old warrant and the new warrant. I think the fact that I have exhibits that show the independent basis for the new warrant are very relevant.
I don't think they're relevant, and I don't think they're necessary to show the independent source information that she's referring to. So I would re-urge my objection.
Well, it depends on whether it's relevant or not, depends on what your argument is going to be. And then we can address whether or not a witness should be here testifying. So if your argument is going to be that the
sustained. That single word is a massive victory for the defense. The judge agrees with the defense's objection and blocks the state's exhibits from being entered into evidence by narrowly defining her argument to the four corners of the new warrant. The defense attorney completely outmaneuvered the prosecutor. She prevented the state from bringing in outside information that might have explained away the warrant's potential flaws. The prosecutor is now stuck. She must defend the warrant based only on the potentially weak and insufficient text written in the affidavit itself. The momentum in this hearing has just swung decisively in the defense's favor. They have successfully limited the battlefield to grounds they believe they can win on.
New search warrant is not based on anything new, then that's where we are.
Well, I'm arguing that the new search warrant is wholly insufficient in detail. And part of that argument goes to the fact that the information contained within the warrant does not give any information as to when this information was acquired, whether or not it was. I'm kind of getting into the depths of it.
So let me ask you this then. So are you withdrawing Defense Exhibit A? Because then what is the purpose of saying Defense Exhibit A is the search warrant where that was previously suppressed? If you're just arguing about the sufficiency in Defendant's Exhibit number B, then what is the purpose of Defense Exhibit number A?
I offered A.
Just when you think the argument will be about complex legal precedents, the judge herself spots a potentially fatal and shockingly simple flaw. The new search warrant affidavit, the document providing the basis for the search, has a date and a year, but it's missing the month. This is a huge problem. Search warrants are built on the concept of probable cause, which requires timely, not stale information. Without a month, there's no way to prove when the information was obtained. Was it a week ago or 10 months ago? This single missing word could render the entire warrant invalid. The judge, recognizing the gravity of this clerical error, wisely puts the hearing on pause to give both sides time to research this specific issue. The fate of the key evidence might not hang on a brilliant legal argument, but on a typo.
To illustrate the additions to search warrant or Exhibit B. And also what I find of significance, and I hope the court will agree, is the fact that that second search warrant was obtained 2 days before.
The decision is made. Court is adjourned until 10 a.m. tomorrow. The missing month issue is so significant that the judge wants both sides to come back fully prepared with case law to argue its impact. This shows that despite her earlier show of frustration with the defense team's scheduling, Judge Boyd is committed to a thorough and fair process. She could have made a ruling on the spot, but instead she's giving both the prosecution and the defense a fair shot to build their case around this unexpected development. For the defense, this is a golden opportunity. They have a full evening to find legal precedent that says a dateless, stale warrant is an unconstitutional warrant. The prosecution, meanwhile, is now scrambling to find a way to save their key piece of evidence.
The first search warrant was ruled out. So there were a couple days where there were two active warrants on the same device. So I thought that chronology, that awkward chronology was significant.
So you're not submitting Defense Exhibit B for the court to review it and determine whether or not there's new evidence that was placed.
Well,
and Defendant's Exhibit.
No, I'm arguing that my arguments are tied to the contents, the four corners of the second warrant.
Okay. So are you withdrawing Defense Exhibit A?
No.
Okay.
May I proceed?
Yes.
Okay.
Oh, everyone, you can remain seated.
Okay. Okay.
I was offering my exhibits.
All right. Let me take a look at them.
All right. Okay.
As the hearing wraps up, the defense isn't done. The attorney brings up future motions in limine, specifically regarding extraneous offenses and prior bad acts. A motion in limine is a request made before trial to exclude certain evidence. Here, the defense wants to prevent the prosecution from mentioning any of Ruiz's past misdeeds that aren't directly related to this specific charge. Why? Because that kind of information can be incredibly prejudicial. It can easily lead a jury to think, well, he's a bad guy, so he probably did this too, which is known as propensity evidence and is generally not allowed. The defense is already planning its trial strategy, building a firewall to keep the jury focused only on the facts of this case, not on Ruiz's past.
We're off the record while they review the exhibits. All right, Mark Costa.
Yes, sir.
Have you been in touch with your attorney?
Just got the phone with their office. They told me just to sit tight because he said
All right.
they was wrong.
Okay. All right. Just have a seat. Could I see the file on Costa? Just one moment. I'm going to get your file, okay? And we may be able to take care of you. Dinah, just give me 3 minutes to get his file and see what's going on with this attorney.
Yeah.
All right. We're back on the record. Have y'all had a chance to review everything?
Yes, so this is, I'm going to re-urge objections on the basis of relevance and not properly authenticated and hearsay.
All right. How's this relevant?
Your Honor, as I stated, and as defense counsel has alluded to in her objection to my item, I think it's important just for you and for the record to show that there was an independent basis that formed this new affidavit, that it is wholly separate from the former.
All right. So it's my understanding that the defense is not going to be arguing, and if I'm wrong, correct me, that the defense is not arguing that there wasn't new information. They're just looking at strictly at the four corners of this affidavit and for the court to make a decision on whether or not this should be suppressed based upon the four corners of Defense Exhibit B. Am I incorrect?
No, you're correct, Your Honor. Our argument is based on the quality and sufficiency of this additional information.
All right. So then defense's objection to State's Exhibit A and B, that objection will be sustained.
Thank you, Judge.
You're welcome. Is there anything else with regards to the motion to suppress? Any other evidence that needs to be admitted?
No, Your Honor.
All right. So with regards to that, as the court has brought up the issue with the search warrant that has a date and a year, but no month, if you all want time to make those arguments or formulate those arguments, you're more than welcome to do that. Defense, I believe the state is calling down the appellate section. And I know that sometimes defense doesn't have an appellate section to call down. So I do have Defense Exhibit B, Defense Exhibit A. And if you would all like a chance to formulate your arguments, you're more than welcome to do that. And I will hear your arguments. Or if you would like to all come back tomorrow morning and have your case law, if there is case law as it relates to that, the court will entertain that. However you all wish to proceed, I want to give the defense ample opportunity to consult their appellate section as well.
Well, I can proceed. I have other arguments, but maybe it is well advised to look at that issue in before I argue everything.
All right. So with regards to the motion to suppress, you all are going to be back here on tomorrow at 9 a.m. Do not remain in the box without pulling the file if you all are ready. And so at 9 a.m., the court will hear your argument as it relates to that. to the motion to suppress.
We will be here at 9 a.m.
Yes, I have a plea that was moved to tomorrow morning. The 186 is in trial. They asked me to be there right at 9 to get that plea done. The paperwork's ready. So
Sure.
if you don't mind, I'll go get that done. And it's a relatively simple matter.
All right, so then I'll push this then to 10.
Okay,
All right, so 10 for the court to hear your arguments with regards to whether or not defense exhibit B should be suppressed or not.
yes, okay.
All right, any other motions?
Not at this time, Your Honor.
All right, so then I will hear your arguments on tomorrow at 10.
Okay,
All right,
thank you, Judge. May I be excused?
yes. Is
Okay.
there anything else y'all are sure? Because the jury trial is upon us.
Well, there are some matters of limine and things like that.
And what I can tell you, I will hear your arguments on the motion in limine, but a lot of times with the motion in limine, I haven't heard any facts of the case, so I don't know whether it should be limited out or not. So usually what I do before any party wants to ask any questions about that or talk about that, they need to approach first.
Okay, so another thing I would always ask for a limine is with regard to extraneous offenses and prior bad acts. So I would definitely ask for a motion on limine with regard to that.
Sure, we can do that. And then it will just be, you all will have to approach before you go into those matters. So if you want to do the motion in limines before the start of trial, you're more than welcome to do that. Or if you would like to hear them tomorrow, I can hear them tomorrow.
Either one.
I'll do my best to have it to urge what I can on the limine tomorrow.
Okay. And have you all let your client know what the offer is?
Yes.
Okay.
Yes, and I think that we submitted a probation app, an election of punishment, or we did complete those things. So we'll have those ready to submit to the court.
All right, that, and then if he were to be found guilty, judge or jury for punishment.
What a day in court. We saw a defense team come out swinging, trying and failing to get the cameras shut off. We witnessed the strange procedural drama of a lead attorney leaving mid-hearing, forcing the defendant to waive his rights on the record. And at the center of it all was the legal battle over a critical piece of evidence, the cell phone. After an earlier warrant was already tossed, the fight over the second one took a shocking turn. The judge herself discovered a simple but potentially catastrophic error, a missing month that could render the entire warrant invalid. The outcome of that motion now hangs in the balance, a decision that could either arm the prosecution with damning evidence or cripple their case entirely. What do you think the judge will decide? Let us know in the comments below and subscribe for more in-depth courtroom analysis.